Good morning, good afternoon, good evening, wherever you may be listening to us. Welcome to our live podcast. This is Dr. Olu Asekun here. Apology for not coming on live last week. I was in transit. I was unable to have access to the podcast. Okay, welcome. Invite your friends, family, colleagues, and join us as we start this new edition of the podcast. As usual, we'll go over the updates and then go into questions and answers. So, I have a few updates. The very first one is that, thank you. The very first one is that the policy on detaining asylees and refugees who have been granted asylum but have not filed adjustment application within 1 year, that policy has been clarified. For those who listen to us regularly, you will recall that I mentioned recently that USCIS or DHS released a new policy that anyone who has been granted asylum for more than 1 year and is yet to apply for adjustment of status, those people will be arrested and detained. Now, that policy is clarified. The clarification is that because USCIS is reviewing all asylum applications granted between January 2021 and January 2025, anyone granted asylum within those periods who have not applied for adjustment of status after the 1 year of being granted, those people will be detained during the review period. So that is a clarification. What that means is that if you are granted, let's say you are granted asylum January 2024, that means that by January 2025, you are eligible to apply for adjustment of status. However, what this policy is saying is that if you have not applied for adjustment of status, you will be detained. You will be arrested and detained. So throughout the process of this review, remember, we don't know how long this review will take. If the review take 1 month, you'll be detained for 1 month. If the review take 1 year, you'll be detained for 1 year. So the clarification is that anyone who falls into this category will be detained for the period of the review. And of course, if after the review, they believe that the asylum was granted wrongly, it means that the asylum will be revoked, and since the person is still detained, it will now incur expedited processing, expedited removal proceedings. So that is a clarification, which I don't believe is really anything, there's really nothing good about it. It's not in any way different from what we stated before, but at least they clarified it. So if you have been granted asylum and it's been 1 year since you are granted, if you have not applied for adjustment of status, you need to do it as quickly as possible. You need to apply immediately because you may be subject to detention under this new policy. Okay. The next thing I want to talk about is that, again, the DHS recently started implementing a policy where people are deported to third countries, to countries that they are not from. Of course, a few people have been deported to different African countries, even though they are not from those countries. Now, a federal judge has ruled that it is illegal for Trump administration to deport people to third countries other than their own countries without notice or providing opportunity for them to challenge the removal. So this decision has been found to be illegal by a federal judge. The question now is, I don't know how this decision is going to affect those who have already been deported. I know that those who are yet to be deported, they will benefit from this decision. But what about those who have been deported to third countries? As of today, I don't know what is going to happen to those people. And of course, personally, I've not read the decision in details. So I got this information through the American Immigration Lawyers Association. So I've not personally read the decision in details. Even if I do, I don't think the decision will talk about people who have been deported, because the decision will probably be addressing the plaintiffs, those who went to court to challenge this decision. But again, when we have additional information about this, we will provide it. But as of today, a federal judge has ruled that it is illegal for Trump administration to deport people to countries they are not from. So we will find out what will happen to those who have been deported already. I mean, when I was reading this from the American Immigration Association platform, I saw that some people were actually deported to Cameroon, where war was ongoing. Can you imagine a country that is having a war, and now you are deporting people who are not from that country to that place? This is ridiculous. There's a lot of illegality under this administration, but hopefully our court system will rise up to the occasion and put them in their right perspective. Okay. The next thing I want to talk about is that this is another dangerous precedent by the Board of Immigration Appeal. You see, Trump administration has really been, they have really been pushing the limit. They have been testing the limit, and they keep going because nobody has challenged them. Now, the Board of Immigration Appeal, the BIA, on February 26, 2026, they ruled that 237A1H waiver only applied to fraud at the time of entry into the U.S. and not at the time of adjustment of status. They are overruling age-long precedent. This is unbelievable. In fact, when I read this, I developed stomach upset, because I can tell you this is just an indirect way of deporting people who are otherwise eligible for relief. For those who may be wondering what 237A1H waiver is all about, this is a waiver that is available for anyone that is accused of obtaining green card by fraud. If someone is accused of obtaining green card by fraud, and that person has at least one U.S. citizen qualifying relative, either parent, spouse, or child, that person is eligible for 237A1H waiver. And that has been the precedent for decades. Now, the Board of Immigration Appeal is saying that this waiver is only applicable to someone who committed the fraud at the time they are entering the U.S., not somebody who applied for green card in the U.S. This is ridiculous. I am hoping that whoever is the respondent in this case will go on to file an appeal. But on February 26, this is the ridiculous judgment from the Board of Immigration Appeal. They are effectively removing a waiver that was created by Congress. It is In fact, I never believed that in my lifetime in the United States, I will witness a situation where an administrative agency, an administrative court, will by ruling eliminate an act of Congress. 237A1H waiver is an act of Congress. It was a law passed by Congress to provide relief for anyone who is accused of obtaining green card by fraud. Now, the Trump administration, by their stooges that were put at the Board of Immigration Appeal, they are saying that this waiver is no longer available for anyone who applies for green card in the United States. They are claiming that this waiver is exclusively for people who committed the fraud at the time they were entering the U.S. That is not the language of the statute. It is my hope that the respondent in this case will appeal to federal court. But it is what it is. For the purpose of this podcast, we can only provide information, and that is what we are doing right now. In fact, as I talk about this, I get upset. I really, really get upset. And it is increasingly becoming frustrating for anyone to continue to practice immigration law in this country under this administration with the level of disruptions, with the level of illegality, with the level of ridiculous precedent that the Board of Immigration Appeal is setting up. I'm saying this live, and I can challenge any of them to a debate on law. This is ridiculous. Unfortunately, I don't have the capacity to go and file an appeal in this case because I don't even know who the respondent is. I don't know anything about the case. But I wish this was my client. I will go all the way to the U.S. Supreme Court over this. This is ridiculous. The Congress of the United States has the responsibility to make laws for this country. And they have made a law creating a waiver for people. And an administrative agency, a Board of Immigration Appeal, that is not even a judicial court, that is not a court established by the Constitution, that is a court established by the executive arm of government, is changing the law that was passed by the Congress. This is ridiculous. I never believed that I would witness this in the United States. But of course, President Donald Trump has showed us clearly that the U.S. is not different from the so-called shithole countries. This is ridiculous. This is more than shithole country. And I never believed that this will happen in my lifetime. I'm going to go ahead and discuss the next update before I go into questions. H-1B registration period started last week, that is March 4, and is going to be on until March 19, 2026. So, anyone who is thinking of applying for H-1B, any employer who is thinking of sponsoring an employee for H-1B position, this is the time to register. The registration already started last week, March 4, and is going to end on March 19. How much is the registration fee again?
Registration fee?
Yes, please clarify. Yeah, so if there is any employer planning to hire anyone on H-1B, even though it is not certain, as I stated before, this year they are going to make their selection based on salary and the position. So if someone is offered a higher salary, they stand a better chance of being selected under this new policy of this administration. 215. Okay, the registration fee is $215, but registration can only be made by an employer. H-1B is not a self-petition. The next thing I want to talk about, you will recall that recently I talked about the BIA position trying to reduce the appeal period from 30 days to 10 days. In fact, I don't know. The more I talk about the BIA, the more I get irritated this morning. I really don't know what is wrong with this set of people that is currently sitting at the Board of Immigration Appeal. I really don't know what their problem is. I mean, administration of justice should be their primary goal, but they are doing everything humanly possible to deprive people of access to justice. How can somebody go through law school and not know that it is incumbent on them to ensure that everyone have access to justice? Here is our own Board of Immigration Appeal saying that the appeal period, which is currently 30 days, they are going to reduce it to 10 days. Of course, a federal court blocked that decision. In fact, they blocked it the day it was supposed to take effect. So a federal court has already blocked it. So hopefully they will reverse a lot of other things, other ridiculous decisions that are coming out from that. I don't want to use the word racist, but I want to say a compassionate Board of Immigration Appeal as currently constituted. The next thing, there is nothing anybody can do about me. I'm already 60 years plus. I'm close to retirement. Even if you want to take my license, I don't give a dime. You are doing what is legally wrong, and I have the right as an American citizen to point it out. So I'm not afraid. Whoever is listening to me, whatever you think you can do to silence me cannot work. Even if I retire today, I will live good. The next thing I want to talk about is the Department of State is planning to amend the DV lottery rules. So for those countries that are still eligible to participate in the DV lottery, the rules are going to change in the next lottery, once they release the next lottery rules. So under the proposed rule, applicants will now have to attach a copy of, they will have to attach a copy of unexpired passport, the biometric page of their unexpired passport. They will have to attach it to the lottery application. They will also have to provide the information of their passport to the lottery application. So I don't know, this is among many other changes that are coming. So for countries that still participate in the lottery, you have to be on the lookout for some of these amendments that are coming. In fact, this BIA issue is really making me upset. I think I'm going to stop here. Let's go into questions. Because if I continue, I probably will get to a stage that they will have to arrest me. They are just bunch of incompetent fools. Let's go into question, please. Yes. I mean, I enjoy law. What is the purpose? How can there are three arms of government: the executive, the legislature, and the judiciary? It is the responsibility of the legislature to pass law. So how can Congress pass a law and provide a waiver, and the BIA, which is under the executive, is saying that those waivers are not available? That is ridiculous. And I can tell you there are hundreds of thousands of people who currently have application for 237A1H waiver pending at various immigration courts across the country. Even in this office, I have clients who have applications that are pending. Now you are changing the rule in the middle of a game. I have appeals that are pending currently. So which means that this decision is going to be applied to all these cases that are pending. This is wickedness. Let's go into the question, please. The first question today. Greetings, sir. I'm a Nigerian. I have been married to my American wife for 5 years, but got my green card 3 years ago, August 16th precisely. Can I file for citizenship this year considering the pause? 3 years ago will be, we are currently in 2026. When would 3 years ago? I want to calculate. So that would be August 2023. So it said 3 years ago. I don't know why they can't just put a specific date. Okay, let's assume it's August 2023. So 24, 25, 26. If it is August 2023, it's not eligible yet. Well, what I'm just going to tell you, whoever sent this question, go and look at your green card. At the bottom of it, it will say resident since. So whatever date that is there, calculate 3 years from that date. For as long as you are still married to your spouse, 3 years from the date of your green card that says resident since, 3 years from that day, you can apply for citizenship. Irrespective of the pause, you can still submit your application. Whenever they resume, you will be on the line rather than starting all over again. Please go to the next question. Dear doctor, thanks for all you do. Please, does the USCIS pause on the 75 countries affecting approval for I-765 and I-131? Also, if someone has a pending I-485 application, can the person file for F2? No. The last question first. You cannot file for F2 if you have I-485 application. I-485 application is an immigrant application. F2 is a non-immigrant application. So immigrant intent will defeat F2. So you cannot do that. Now, as to whether they are still approving, can somebody confirm that? I have lost touch. Have they been approving employment authorization for citizens of the 75 countries? Have we been receiving employment authorization in this office? Do you know? Can you please tell Anna to confirm? I just want to know so that I'm giving out accurate information. I know that we still get approval, but I'm talking about from the 75 countries. If you can verify. Okay, let's go to the next question while waiting for our response. Good day, Dr. Olu. I want to join the U.S. Army to fast-track my citizenship. I'm Nigerian, 10-year green card since February 2025. Married to U.S. citizen. You think I will get citizenship quick via military service? Again, this is another thing that I'm unable to verify. Were you able to verify? I asked you to verify it last week. You have not been able to. Okay. Well, I don't have an accurate answer for this person. I had, but I've not been able to verify. I heard that citizens of those 75 countries that are currently on the ban list, they are not being admitted into the military. That is something that I had. I have attempted to verify it. Unfortunately, because I've been out of the country for some time now, I've not been able to verify it. But I will try. Please remind me. I will verify it, and Marissa, please remind me next week to talk about it. Okay. Whether citizens of the 75 countries are being admitted to the military. Okay. Not necessarily the army, the military generally, whether Air Force, Army, Navy, or anything. Okay, next question.
This person only said hello, but I know that he did put his question down here. You want me to go?
Yeah, go to the question. Hello.
Okay. Because he's all the way down.
Is it this one? Yes. Okay. Hello, sir. I have a pending asylum with USCIS. I have attended interview once, and now I got a letter to appear in court stating that I came in with B1, B2, and that I did not return to my country as scheduled. Nothing was mentioned about my pending asylum. Please, your legal advice. Yeah, that simply means that your asylum was not approved by USCIS. When it comes to affirmative asylum, USCIS officers do not have the authority to deny asylum applications. Their authority is one way. They can only approve it if they believe your case, your story. If they don't believe your story, because they do not have the authority to deny it, the only thing they can do is to send you to removal proceedings. But ordinarily, they will have sent you a letter called referral notice. In that letter, they will have explained to you that you should go and represent your asylum case before an immigration judge. But because they cannot approve it, the only thing they can do is to send you, or because they cannot deny it, I mean, their authority is one way. If they believe your story, they can approve. If they don't believe your story, they cannot deny. So because they cannot deny, the law only mandates them to send you to removal proceedings, which is what they have done. So they will give you a letter called referral notice. They will also give you a document called notice to appear. So the notice to appear will have a few allegations. Allegations like you are not a citizen of the United States, you are a citizen of Nigeria, you entered the United States on so-so date with authorization to remain until so-so date. You remained in the United States beyond the period authorized. So those are the kind of things that the NTA will contain. It is when you now appear at the immigration court, that is when the judge will ask you whether you received the notice to appear, and if yes, how you want to plead to those allegations, and then you will have the opportunity to represent your case. But right now, it simply means that the USCIS did not believe your story, so they did not approve your asylum. That is why you received this. So it is my advice for you to try to hire an experienced immigration attorney, so that when you go to court, you represent your asylum case and probably have it approved. Next question.
The person that asked about the citizenship earlier,
Yes.
he's saying that they're being enlisted, but citizenship is what he's not sure of. He's currently in the process, he said.
Oh, okay.
To the military.
To the military question.
Yes, yes.
Okay, so, well, to the military question, I understand one of our listeners.
Him.
Okay, the same person who asked the question. Oh, okay.
He said they're being enlisted, but citizenship is what I don't know. I'm currently in the process.
Yeah, well, like I said, even for citizenship, I will still verify, because ordinarily, before the issue of the ban came up, ordinarily, once you join the military, you go for training. I think it's about maybe 3 months training or thereabout. You go for training. On the day that that training ends, that's when you are supposed to be sworn in as a U.S. citizen. But since the travel ban came, I understand that process has been disrupted for citizens from those countries. But I mean, hopefully, since if they are still admitting, that's a good thing. Hopefully, the travel ban thing will be resolved shortly. I mean, the good thing is that this is an election year. Hopefully, many of these unscrupulous people parading themselves as politicians will be kicked out. Next question, please.
No, we haven't gotten any from travel ban countries, no EADs.
Oh, okay. The second question about employment authorization. Yeah, we have just confirmed now in our office here that we have not received any approval of employment authorization for people from travel ban countries. And for those that were approved, we have not received the physical employment authorization card for people from the travel ban countries. So apparently, the travel ban is also affecting employment authorization.
Well, we had one that was approved before the travel ban went into place, got the card in January, but it was approved before.
Before the travel ban. Okay, yeah. Okay, so next question. Okay. More blessing for you and your team. Amen. I am Nigerian. I have EAD extension that will expire August 2026. I have I-797 for adjustment of status for asylum granted by the Immigration Court. I have CBP from I-94. Move up. Stamped asylum status granted indefinitely in 2024. Am I authorized to work beyond August? What document should I show my employer? Oh yes, you are authorized to work. The asylum, the letter granting you asylum by itself is also work authorization. So you can work beyond the August of 2026 or whenever the employment authorization expires. Yes, you are legally authorized to work. You can continue to work. Next question, please. Good day, sir. Foreign state of chargeability, Nigeria interview. Oh, foreign state of chargeability, Nigeria. Interview country, UK, legally staying. Visa date is current, EB2 NIW in the UK. They are currently scheduling interview for my DQ date. But Nigeria is a year plus behind. Which country scheduling date will NVC use to schedule my interview in the UK? Since you are not a citizen of the UK, they are going to use Nigeria. They will only use a different country if you have citizenship in multiple countries. But from this statement, you are only legally authorized to stay in the UK. You are not a British citizen. So for that reason, they are going to use Nigeria only in your case. Next question, please. Good afternoon, Dr. Olu. We appreciate you for everything you do for humanity. Thank you. Needed your advice on the use of address to mail adjustment of status regards to family immigration. Use of address as in what address to mail it to? Well, this will depend on a number of factors. Number one, it will depend on where you yourself you are living, you are staying, and of course, that is what will determine whether. Then I don't know, is this a concurrent adjustment, I-130 and I-485?
She sent additional questions.
Oh, okay.
This is more information.
Okay. On the I-130 receipt notice, the mentioned address. Okay, that means you already filed I-130 separately.
Yeah.
Okay. On the I-130 receipt notice, the mentioned address, Vermont Service Center, U.S. Citizenship and Immigration Service. No. That is not the address to mail your adjustment. That is the address where your I-130 is pending. So for the adjustment itself, you need to, for me to be able to tell you where to mail it, the accurate place, we need to know your own location, because your location also determines where your application will be filed, but not the address on the I-130. If you send it to the address on the I-130, it will be rejected.
Yeah, she sent that question, which she already answered.
Okay, next question, please. If that person responded with our current location, please tag the person and provide the right address for him or her. Next question, please. God bless you, sir. I have an active I-130 ongoing, but due to abuse, I want to apply for VAWA. If it succeeds, okay, but if otherwise, can I still renew the I-130 afterwards if we are still together? You can still resubmit it, but it will definitely raise a lot of issues. It will definitely raise a lot of issues. In this situation, I will advise you to seek advice from an immigration lawyer, because you don't. I'm originally from Nigeria, from Yoruba tribe in particular, and we have a popular adage that says that you don't go to court with somebody and come back home and remain family members. So if you accuse somebody of abusing you, you don't come back and expect that person to be your sponsor for an I-130. That will raise a lot of issues, because if you come back and refile the I-130, during the interview, they are going to bring up the issue of the issue of the abuse. And if your spouse didn't know about it before, now he or she is going to know. And that may create the thing is, can you file it? Yes. Is it advisable? Absolutely not. So if you don't have evidence of VAWA, don't go that route. If you do, forget about I-130, go for VAWA. But if you don't have the evidence, don't even start. Next question, please. Oh, okay. Thanks for a great job you are doing. Please, can you reiterate the visa ban again, the 90-day and the 180 days, as it affects an applicant I-130, I-485 in the US from Nigeria? Well, the 90-day is different from the 180-day. The 90-day, that one is to give USCIS the opportunity to review their mode of operation. I think I'm okay. Yeah. Sorry about that. The 90 days was to give USCIS an opportunity to review their mode of operation, to come up with new policies on the way to enforce the Trump administration enhanced immigration policy review. So what that means is that because this administration wants to be extremely strict with the adjudication of applications and petitions, so the administration is giving USCIS a 90 days time, one, to first pause all adjudication of cases and then come up with new policies on how the enhanced method is going to be implemented. That is the purpose of the 90 days. That does not affect the travel ban countries. As far as the travel ban country, the 90-day thing, that one is universal. It has to do with enhancement of immigration benefit review. As far as the travel ban, that one is to be reviewed after 180 days. So all the 75 countries that are listed under the travel ban, right now, the USCIS have been instructed to pause adjudication. So they cannot approve or deny. They should just pause adjudication. That is the instruction. Now, they will review it after 180 days. So because it was effective in January, 180 days is going to be in June. So in June is when they will review it. So when they review it, additional countries may be added and some countries may be removed. And it may not even change. So it's going to be one of three things. One of three things. Either additional countries are added, either or some countries that are currently on the list are removed, or nothing changes at all. They may keep it the way it is, but they are going to review it in 180 days' time. So that is the difference between the 90-day and the 180 days. The 90 days is not limited to the travel countries. It affects every immigration policy. They just want immigration to come up with new ways of vetting immigration applications and petitions so that they want to prevent fraud according to the administration. Next question, please. Good afternoon, sir. Thank you for all you do. Do you have idea of when we will hear any update about the 75 countries ban? Oh yes, I just talked about that now. That's going to be in 180 days time. 180 days effective January. So that's going to be in June. So by June, they will tell us whether they they are changing anything. You will recall that in 2017, during Donald Trump's first administration, he actually introduced travel ban at that time. And I remember Nigeria was on that list at that time. But when they review it after 180 days, Nigeria was taken off of that list at the time. So right now, all we know is that they will review it in 180 days time, which is going to be in June. But we don't know whether countries will be removed or added, or even whether the whole thing will be left alone the way it is right now. We don't know. But it will be June that we will know. Next question, please. Hello, Dr. Asekun. For the past 2 years, USCIS has not made a decision regarding my EB2 petition. My visa is current. What will your advice for me? Should I submit an adjustment request now? Oh yes, if your visa is current. Hold on, I take that back. This is a very technical issue. Okay, I think there's a B part of the question. Let me read that first before I answer that question. Should I submit an adjustment request now? Should I use premium processing instead? I'm asking because I'm from one of the temporarily banned countries, and I'm not sure if USCIS is still adjudicating application. Well, as I already mentioned this morning, USCIS is not able to take decision right now on any application from any of the 75 travel ban countries. However, this is what I'm going to tell you. Each of the options, I will not advise you to take any of the options. My advice for you will be, well, based on your circumstances, let me tell you what I'm thinking. Number one, applying for premium processing is going to be a waste of money. Waste of money because I think it was just yesterday that they increased the fee for premium processing again.
That was on March the 1st.
Yeah, okay. I heard about it yesterday, but the increase was on March 1st. Effective March 1st. They increased the premium processing fee. Now, if you pay the premium processing fee, because USCIS cannot take a decision right now, what is the point? You are still going to be in the same situation. Whether it is premium processing or not, USCIS is not able to take a decision right now based on the travel ban policy. So because of that, applying for premium processing, in my opinion, is just going to be a waste of money. Secondly, should you apply for adjustment of status? That depends on a number of factors. Number one, because this is an employment-based petition, employment-based petitions require that you must be maintaining legal status at all times. Now, visa is current, you are maintaining legal status, but the moment you apply for adjustment of status, you submit I-485, it is going to invalidate your non-immigrant status. Whatever non-immigrant status you are in currently is going to invalidate it, because immigrant and non-immigrant status, both of them does not work together. If you apply for immigrant status, that will be an evidence of immigrant intent, which means that you will no longer qualify for non-immigrant status. So the danger of applying for adjustment of status now is that, what if, I don't know how strong your case is, but what if the is this EB2? Yeah. What if the EB2 petition is denied? If it is denied and you already submitted the adjustment application, at the end of the day, you are going to be out of status. So that is the danger, that is the risk. Ordinarily, if not for the travel ban, I would have advised that you submit premium processing so that you know your position. If it is approved, then you apply for adjustment. If it is not approved, because you are still in status, there will be no problem. But if you go ahead and file the I-485 and then they deny it after, there is going to be problem. So that is the risk that is involved. So for that reason, even though I don't know the details of your petition, I don't know how strong your petition is. But as based on general information, I'm going to advise you to hold on and not submit application for adjustment until USCIS is able to adjudicate the petition, so that you don't risk being out of status at the end of the day. Next question, please.
Somebody just thanking you. Okay, this is the question.
Okay. Good day, sir. I greet you and your team, sir. Thank you. Please, sir, is it true that who got asylum granted must apply for green card after 1 year? And my case was approved last year, March, with my family in court. Oh, yes. Apparently, this person joined us late. Yes, it is true. It is true that if you are granted asylum, you have to apply for green card 1 year after the date you are granted. And in fact, under this Trump administration, they just released a policy stating that if you have been granted asylum and you are supposed to apply for adjustment of status 1 year after, if you have not applied, you are going to be detained, and they are going to detain you throughout the process that they are going to do their review. Even though based on this fact that you presented, because your asylum was granted by an immigration judge in court, I don't believe that the review will affect you. However, the policy of being detained may affect you. So if I'm in your shoes, I will not waste 1 day. I will not delay 1 day. Since you have been granted asylum already, once it is 1 year, go ahead and submit application for adjustment for you and your family. Next question, please. Good afternoon, doctor and team. Good afternoon. No question.
Okay,
I think
sorry,
it's just good.
There was a third question to that other one. The one that said 102, 202. He sent this one too. I don't know if you already answered that one.
No, I already answered it. It's just asking what honest advice will you give. I already dealt with that extensively.
Now this person right here. There's more questions from her here.
Okay. Please, who got asylum granted must apply for green card after 1 year. I already answered that. And my case was approved last year, March, with my family in court by immigration judge. Yes, so we are already in March, so it's already 1 year. So, okay, we are scaring to apply for green card in this time. Please advise me, sir. No, you should not be scared. Go ahead and apply. Your application, your asylum was granted by an immigration judge. So there is nothing USCIS can do about that. So go ahead. There is nothing to fear. Those who are granted by USCIS are the ones that should have reasons to be concerned, because you are granted by a judge, and once you are granted, the government have 1 year to file an appeal. And if the government have not appealed, or even if they appeal and the appeal is pending, for as long as you have been granted asylum for 1 year, you are eligible to apply for adjustment of status. Go ahead and apply to prevent yourself from being detained. I'm sure that the administration knows that a lot of people will probably not file anything for fear of their case being reviewed. That is why they introduced this detention issue, so as to force people to apply and then give them an opportunity to review the asylum. But in your case, you will escape that because you are granted by an immigration judge, not by USCIS. So there's nothing to be fearful of. Go ahead and apply. And if you are still afraid, contact our office. We will help you. Number 3, from the same person?
Yes.
Okay. And is every adjustment must go for interview, including asylum granted? Oh, yes. Asylum is different from adjustment of status. Yes, for adjustment of status, you will be invited for interview, but not at the asylum office. So you will be invited for interview. The only thing I will tell you is that excuse me, if you are invited for interview, make sure you put your house in order, go over all your asylum story, everything that was presented in court, familiarize yourself with it so that there will be no risk. But like I told you, if you are still afraid, contact our office, we will help you. Next question, please. Good afternoon, sir. Welcome back. Thank you. Yeah, he says welcome back, sir. Thank you. Yeah, another one. Good afternoon, sir. Thank you. Okay, next one. Good day, sir. My husband AOS second interview was cancelled. K1 visa. The first interview was just 15 minutes. What does this mean for us? We are in New Jersey. It simply means that because of the travel ban, the embassy is not able to approve your application at this time, your petition at this time. So you just have to wait until they review the situation. Like I said before, they will revisit it in 180 days, which is 6 months. That's going to be in June. The unfortunate aspect is that K1 is only, the approved K1 is only valid for 3 months, 90 days. So if this is not resolved by June, then it may affect your K1 application. But if by June, if they review it and they take out your home country from the list, I believe that the embassy, the Department of State, they still have the authority to extend the approval period of the K1, and then they will still be able to get it approved. But for now, there's really nothing anybody can do other than to wait. That's the unfortunate situation. But the interview was cancelled because they couldn't approve it. So that's probably their reason. They couldn't grant it. Yeah. Next one. God bless you, sir, and your team. Amen. Thank you.
Amen.
Next one. Thank you for all you do. God will continue to bless you and your team members. Amen. Thank you. Next one. Is USCIS still approving I-140 for people from the banned countries? I haven't seen approvals lately. No, they are not able to, because the policy says that they must pause everything right now. They cannot take a decision. Not only approval, they cannot also not deny. So the policy says no approval, no denial, just hold on. That is what the policy says. So they are not able to take a decision right now. So we just have to wait. Next one, please. Good afternoon, sir. With IRS sharing biodata with USCIS, do you advise we file for tax? For context, I entered on a B1, B2 visa, applied for asylum and withholding of removal after 2 years with no arrest. Please move it forward. Is this? I think that should be. Okay, with no arrest. How long does it take to request for FOIA? Is it the same person?
Yes.
Oh, but this is a completely different question. Okay. Well, because you have a pending asylum case, I will advise you, go ahead and apply for and file your taxes. Whether IRS share data with USCIS or not, the fact still remains that they already have your information through your asylum. You already have a pending asylum case. So you don't lose anything by filing your taxes, because you have to weigh your options. Filing versus not filing. Filing will probably give you some benefit in the future. Not filing will constitute a negative equity for you in the future. You never know what may happen. You may find yourself in a situation where you may have to apply for something that requires good moral character, or to weigh positive versus negative equity, or something that is discretionary in nature. These are the things they will use against you. If you are working, you are supposed to file taxes and you didn't file it, it may work against you. But the USCIS already have your data anyway. They already know that you are here. They already have your application for asylum. So there's really nothing that there's nothing new that IRS is going to provide for them. they probably already have access to your social security number. So it doesn't really cost you anything. Go ahead and file your taxes. The benefit outweigh the disadvantage. Next question. Okay, how long does it take to request for FOIA? That was the second part of the question. Well, it depends on a number of factors. I don't know if you file your asylum electronically or paper form. If it is filed electronically, I believe that FOIA, you will get it within 30 days. But if it is paper form, it may take a little longer, because for electronic one, all they need to do is just to download it and send it to you. But for paper form, it will require them, one, to first locate your file, two, to scan it, and then before they respond to you. So it takes longer if it is a paper filing. But if it is electronic filing, you get your FOIA within 30 days. Next question, please. Welcome back, Doc. Thank you. We missed you. We thank God for your safe travel. Thank you. Thank you. I appreciate that. Thank you so much. Did I miss one?
That one.
Which one?
The one that says question, can tax ID file tax?
Oh, yes. Oh, yes. Tax ID can file tax. The only thing is, I don't know whether it was last year when I was answering questions as to whether it is advisable for people to file taxes and all of that. And I said yes, because for the same reason I just explained, that sometimes when you file, it has its advantage. Then it was subsequently that the issue of IRS sharing data with USCIS came up. But if you already have your tax ID anyway, even if they share it, you already have it. So it's not going to change anything. Go ahead and file your taxes. It is people who, as at now, does not have Social Security and does not have tax ID and does not have legal status. For those kind of people, if I'm in your shoes, I will pause right now before filing any tax. Okay, next question. Good day, sir. Thanks for all you do and your team. Thank you. My spouse is applying I-130 and 484. What is 484? Maybe you want to talk about 485. Okay. Other forms are not online. How do I make the application for form 765846? Every single form is online.
Available to download online.
Every single form is available to download online. However, not all forms can be filed electronically. For example, I-485 cannot be filed electronically. That is application for green card, application for adjustment of status. It cannot be filed electronically, but it can be downloaded. Every form is online and can be downloaded. If you don't know how to do it, go through our website. Go to oluasekun.lawyer and then you click on resources. You will see immigration forms. So click on that. It will give you access to all immigration forms, including I-130, 765, 485, I-131. As for 693, you don't need that. You don't need to download 693. That is application for medical examination. So just look at the immigration approved medical doctors and go to their office. They are the one that will give you the I-693, the medical examination form. Even though it is online, if you want to download it, you can download it. But generally, the medical immigration approved doctors will give you one in their office. It is not a form that you can have access to. You just provide your basic information. It is the clinic that will complete it and then seal it. So you have to submit the sealed envelope. You cannot open it. Once you open it, it becomes invalid. You have to redo it. However, if you want to know what is inside, you can request the clinic to give you a copy of whatever it is that they sealed in the envelope. Next question, please. You are welcome, sir. Glory be to God for Johnny Masses. Thank you. Thank you. Good day, Dr. Olu.
You already answered this one.
Okay. Okay. Next one. I'm F1 with asylum EAD, but I've used my EAD and in the process of NIW, EB2 NIW. I'm still in F1 status with no issues. The attorney said that if approved, I have to readjust as consular processing. Please advise, sir. Based on this fact, I don't think that is true. Based on this fact. In fact, based on this fact, if you step out of the country, the probability of getting approved will be slim because of the asylum application that you file. However, as far as adjustment of status is concerned, based on employment, EB2, for as long as you are maintaining legal status, you can actually adjust status in the US without departing, except if you fall into some categories. For example, because if you said you are in F1, I hope your F1 is not connected with a J1, because there are some F1s that are connected with a J1. But if it is a regular F1, academic studies, that is not connected with a J1, you should be able to adjust status. But if you may be subject to the 2 foreign residency requirement, so in that situation, you will need to step out and adjust status outside of the United States. But if it is a regular F1 academic student and you are maintaining legal status, you can actually adjust your status in the US without leaving the United States. Next question, please. Thanks for all you do. Sorry. Please, can I start applying for Form I-824, follow to join for my wife and kids in Nigeria? I have approved I-360 and have applied for I-485 pending. My priority date is October 2021. Unfortunately, no. Follow to join does not, you cannot commence follow to join until your own status have been adjusted to that of legal permanent resident. So in other words, you have to get green card first. You have to be a permanent resident before you can request your wife to join you. If you are not yet a permanent resident, there is nothing to join. So follow to join can only commence after you become a legal permanent resident. So you have to wait until your application is approved before you can start the process. Next question, please. Please, if a case was denied because of Nigerian divorce decree and now in removal, if one file a new case with the right divorce decree, will the person be needing a waiver? Should they file now or wait? I think there's a continuation. Can you please move it off? Or is it just wait? Is it the one that says, will the person be detained by ICE at interview? Okay, go back to the original question. Okay, if a case was denied because of Nigerian divorce decree and now in removal, if one file a new case with the right divorce decree, will the person be needing a waiver? Should they file now or wait? Now, this is not a yes or no question, because the fact of each case may affect my answer to the questions. Every case is different. The fact that a case was denied based on divorce decree that is probably not right, that does not necessarily mean that the case will require a waiver. So it is important to understand the issues. A waiver will only be required if fraud has been established or misrepresentation has been established, or someone lying to a USCIS or a US government officer. Those are the kind of situations that can warrant a waiver. Now, the mere fact that a divorce decree was determined not to be valid.
They're saying that they can't hear you. People are saying they can't hear
Oh, is it that I move away from the...
you. They're saying there's no audio. Okay, can you ask them if they can hear you?
Okay, can you hear me now?
I can hear. Oh no, now I can't.
Can you hear me? I'm talking now. Can somebody hear me?
No, they're saying there's no sound. Is everything
I didn't-
over there?
Well, maybe this thing that has been...
Oh, you're stepping on it. Maybe. Ask him, please.
Can somebody hear me now? Can you guys hear me now? Let me even put that one here to avoid having to step on it again.
There is sound now. Okay.
Oh, okay.
Okay, so they can hear me now. Yeah, it may be that wire that I stepped on. Oh, sorry, I got distracted. What was I talking about? Okay, is it the question? What's the question? Please, if a case was denied, okay, yeah. I was talking about a Nigerian divorce decree or a divorce decree generally that is invalid. Now, the mere fact that a divorce decree was determined to be invalid does not necessarily mean that a waiver situation will be involved. A waiver will only be required if an applicant misrepresented fact to USCIS officer, or an applicant committed fraud, or an applicant was determined to have provided a fake document to an officer of the US government. One of those three situations is the type of thing that would trigger a waiver in this case. The mere fact that the document itself was determined not to be valid is not an evidence of fraud. Every case is different. This type of question will require me to know the details in this situation, because, like I said, number one, the document may be determined to be invalid for various reasons that has nothing to do with fraud or misrepresentation. For example, I've seen a situation where somebody who got married under the Act, I'm addressing a Nigerian situation now. I don't, because this person who sent the question said, or a Nigerian divorce decree. So I'm limiting my answer to Nigerian situation. So I've seen somebody who provided a divorce decree from a customary court in Nigeria, despite the fact that this person engaged in a marriage under the Act. Now, that type of document will be invalid. But does that create a situation of a waiver? No, it does not. Because, number one, the document itself is not fraudulent. Number two, the mere fact that the person submitted the document to USCIS does not mean that the person submitted the fraudulent document. Number three, the only reason that the document is not, the divorce is not valid is because in that scenario, a customary court does not have the legal capacity to terminate a marriage that was entered into under the Act. That is, somebody who went to a registry. If you and your spouse go to the registry to get married, if you are going to divorce, only the High Court can grant a divorce in such a situation. So if you got married at the registry and you provided a divorce that is from a customary court, for the purpose of immigration, that divorce will still be invalid. But does that create a situation of a waiver? No. It does not create any situation that requires a waiver. Even though the document is determined to be invalid, it is because of your ignorance that you didn't realize that only a high court can grant the divorce. That does not mean fraud. That does not mean misrepresentation. It simply means ignorance. So in such a situation, all you need to do is just to maybe file your divorce here, since you now live here, and once the divorce is final, go ahead and refile your application. No waiver is required. It doesn't matter whether you are in removal proceedings or you are refiling with USCIS. In such a situation, no waiver is required. On the other hand, if the document that you submitted was determined by USCIS to be fraudulent, for example, I've seen situations where USCIS will say that they have contacted the issuing authority and they said that this document was not issued by them. That is evidence of fraud. So in such a situation, you may need to file a waiver of misrepresentation or waiver of fraud. So you may need a waiver. So that is why I said this type of question is not a yes or no answer. Every question, every case is different. So it depends on the particular case. It depends on the particular facts of each case. Next question, please.
So this person sent the second one. Will the person be detained by ICE?
No, this has nothing to do with ICE. It has nothing to do with ICE. But if this is in connection, if this is determined to be a fraudulent document that is further determined to be associated with a fraudulent marriage, then it now begins to create complications. But again, that still has nothing to do with ICE, except somebody has been ordered removed or somebody has committed a crime. Even though under this administration, one of their new policy is that during interview, they are going to be arresting and detaining anyone who is determined to have entered into a fraudulent marriage. But of course, that is a separate topic. Fraudulent marriage is not the same issue as a divorce that is found to be invalid. So your marriage can still be legal, while the divorce may still be invalid. That even happens even here in the U.S. Even with divorce documents that were obtained at American court, even in Texas here, that still happens. So that in itself is not a crime. Next question, please. Now my PD is current. Now my priority date is current, and my employer, who is my sponsor, says since I worked on a maybe field that is not nursing, that it will affect me. Please advise. This person didn't provide. What is it that they have pending? Can you please?
It was just about the priority date. It's just.
He says, now that my priority date is current, my employer, who is my sponsor, says since I work in a field that is not nursing, it will affect me. Please advise. I don't know what they mean. Because if this is talking about a labor certification, that should have been filed before I-140 can even be filed. And I-140 is the one that will create a priority date. So I don't understand this question. It doesn't make sense to me, so I don't know what to answer. Please go to the next one. If the person clarify it, I will go back and answer it. Good day, sir. Please, I sent a document received from USCIS to your email, which need to be responded to before 23rd March. Please, how can we schedule an appointment early with you? Well, please note that person.
Tell them to call the office to schedule the appointment, and then we'll see if we can get Anna to speak to them.
Okay, go ahead and call the office, and we will see how we can go about it. Please go ahead and call the office. Okay, next question. You are welcome back from Nigeria. Thank God for joining masses. Thank you. Next question, please.
This is the same person about the NOID.
Good day, sir. My waiting period date for N400 submitted application keeps changing. Is this applicable to fellow Nigerians like me? I applied January 2025, no update yet. Yes, it is changing because of the pause and because of the travel ban. So right now, USCIS has been given 90 days, which I think started in January, to come up with new policies, to come up with new adjudicative way that they will be dealing with this application. And of course, the travel ban also affects 75 countries, of which Nigeria is one. Again, that one will be revisited in June. So until then, USCIS cannot approve N400 application now for citizens of the travel ban countries. So you just have to wait. It is not peculiar to you. Next question. I'm currently on STEM OPT and I have filed I-140 and its priority date is current and still being processed. Is it advisable to go ahead and start the I-485 AOS? Yeah, this is similar to the question that I answered before. Well, if you don't have any other way of keeping yourself in status, you can go ahead and file. Hold on, let me go back to the question. This is not even NIW. No. Can you go back to the question? I'm currently on STEM OPT and I have filed I-140 and its priority date. Okay, the person didn't state the kind of I-140 because I wanted to know if this is I-140 that was filed based on approved labor certification, then my answer would be go ahead and file the adjustment application. But if this I-140 is based on EB1 or EB2, then my previous answer will be applicable in this case because it will depend on your legal status. Because if you file I-485 and
It is NIW.
So if you file I-485 and for any reason the I-140 is denied, then you are going to be out of status. And at that time, it will be difficult to go back to non-immigrant status because now you will have shown immigrant intent, which is inconsistent with a non-immigrant status. Maybe what I will advise you now is to look for a company that can sponsor you on H-1B. At least H-1B is one of the few exceptions to immigrant intent. So you can be on H-1B, apply for adjustment of status. If they deny the I-140, you go back to your H-1B. It will not affect anything because immigrant intent does not affect H-1B, but it affects things like F-1 or most of the other non-immigrant status. So you have to weigh the option. But if I'm in your shoes, this is the time to look for a H-1B sponsor because of the immigrant intent problem. Next question. This is the one I just answered.
So this person, that's the one that said yes, it's NIW.
Yeah, already
Now,
answered.
the one with the issue of the divorce.
Yes.
Okay, so he's just sent this new answer or new information. This one here.
They only said they could not verify the divorce. When they sent a NOID, I filed one here and submitted, but they said they could not approve the green card. The divorce could not be included in retrospect. Yes, this will not require a waiver situation. However, during the interview, you need to be prepared to answer the question because during the interview, they will bring up questions regarding the divorce. But of course, if the divorce is valid, the mere fact that they were not able to verify it does not invalidate it. So it will not require a waiver. Yeah, the NIW, I already answered that.
The last part.
The last one, okay. Not that they tried, they said I have the burden of proof even when I authenticated it at Ministry of Foreign Affairs. Oh, is that still talking about the divorce? Mm-hmm. Oh, yeah, like I said, based on this fact presented, this does not require a waiver. It does not require a waiver situation. So next question. Okay. A friend due to have applied for N400 in January 2026, that's 90 days before 5 years. Can he apply anytime now during this period? He traveled to his hometown for 96 days. Will the delay be minus from his due days? 96 days.
The days.
Okay, will the days be minus from his due date? No. He can apply now. The only problem is if he stay out of the US for 180 days. But if it is just 96 days, no, it doesn't affect anything. He can go ahead and apply now.
You already answered to this one. This one is the next. This is the same thing about the getting into the military. You already answered that. Okay, this one. It just made me laugh.
Oh, they made Dr. Asekun mad today. Oh, yes. I mean, for my listeners, one thing you should know is that it is one thing to do a job. It is another thing for you to enjoy what you do. Law as a profession is something that I enjoy passionately. I love it. And I like to, even as a Christian, the Bible says, present your case, make your case. So I like presenting my argument. I like presenting my case. It is a profession that I enjoy. So when I see people go make this thing, I mean, don't let me go back to it, because the more I try to go back to it, I get upset. So let's just leave it at that. Okay, next question. May God bless you, sir. Currently on adjustment of status with EAD not approved due to partial ban. With EAD expiring soon, can you please advise what one can do to be able to work while waiting for EAD and AOS? Now, let me quickly ask a question. I know that before I travel, we had a couple of clients that scheduled InfoPass appointment to stamp their passport. Do you know if they were stamped?
You meant for the green card?
Yeah, they don't have the physical green card yet. They went to stamp their passport. Okay, yeah. So I'm trying to see.
They did.
Okay. Well, that may not be applicable to this case, because in that case, the green card has already been approved. It's just the production of the green card that was an issue. Okay, that may be a little different. Well, this is a catch-22 situation. Let me read the question again. With the EAD applying very soon, what can one you do? Okay, what you can do, in my opinion, is that you go ahead and submit an application for renewal of your employment authorization. Go ahead and submit it before the expiration of your employment authorization. So once you submit it, you will get a receipt notice. I know that they have reduced the 540 days, but I think it probably went back to the 180 days, the automatic extension. I'm not 100% sure, but I think they restore it back to the 180 days automatic extension. They didn't eliminate it altogether, if I recollect correctly.
They ended it.
They ended the 540 days.
Well, they're talking about the automatic extension.
I'm talking about the initial one that was in the receipt notice before the case. Okay, do we have any EAD receipt notice that we received recently?
Yes.
Can you please verify?
Yes.
Because I want to be sure. I know that the 540 days have been eliminated, but I'm talking of, my impression is that they went back to the original one, which was 180 days, 6 month extension. But let's verify. Okay, While waiting for Kim, can you please go to the next question? I'll come back to address that question. We just want to verify if they are still giving any extension at all. But whether they give extension or not, I will still go ahead and apply for the extension of the employment authorization. Go to the next question, please. Okay. Good afternoon, doctor. My 2-year green card is expiring in November 2026, and I'm from the banned country. What do you think would be a course of action in this case? Well, November is still far away. I mean, they will review this in June. If they review it and they take your country off of the list, then the problem is resolved. If, on the other hand, it is extended without removing your country, you will still go ahead and submit an application for removal of condition. So they will accept the application, they will send you for fingerprinting, and then you wait. But at least you will have a pending application and you will have something that will keep you in status. And it is likely, even though I'm not sure what will happen at that time, but it is likely that the acknowledgement receipt will extend the 2-year green card. But like I said, November is still a long time. So let's wait and see what happens in June. Next question. Doctor, good day to you. Good day, thank you. Please, I want to ask if J1 exchange visa student can work in the USA. Well, it depends. Some J1 can work, some J1 are only for academic purpose. So it depends on the type of J1 that you have. Then also, J1, some J1s requires a 2-year foreign residency requirement. Some are specifically exempt. But if you are exempt, they will write it on your visa. They will write it on your J1 visa that you are exempt from the 2-year foreign residency requirement. So if it is not written there, the presumption is that you are subject to the 2-year foreign residency requirement. But can J1 work? Yes, they can. Next question, please.
This is the same person that asked the question about the EAD. Okay, this one, I don't know what that is.
Oh, okay. He's saying that God will do everything.
Oh, amen.
It's a kind of prayer. Amen.
Okay.
Amen. Next one. Doctor, I live in US under R1 status. Can I apply for R2 for my minor son in Nigeria considering the partial ban? Yes, you can apply, but they may not approve it at this time because they are not issuing any visa right now for non-immigrant status. Even for immigrant, they are not issuing any of those things right now. So I will probably just wait rather than go and get denied. Next question. I'm from the 75 visa pause countries. My employment-based green card was approved recently. My case has been transferred to NVC. Should I go for my visa interview, and do you expect the pause to be lifted soon? Apparently, this person mixed terminology. If your green card was already approved, your case will not be forwarded to the National Visa Center. So I'm assuming that what was approved is your I-140. That's the petition, immigrant petition for alien worker. So when I-140 is approved, you have two options. You can either apply for adjustment of status in the US if you are maintaining legal status, or they send your case to the National Visa Center for you to adjust, to process your case with the, I need a lighter, please. To process your case, I need a lighter, please.
It doesn't say what you, okay. No, it doesn't have the extension.
I'll come back to it. Let me just finish what I'm explaining. So if your I-140, which is what I believe was approved in this case, if your I-140 was approved, there are two options for you to get green card. If you are maintaining legal status and you don't have a J1 visa problem, then you may be able to, and you are maintaining legal status, you may be able to adjust status in the US. On the other hand, if you are already out of status, then they will send your case to the National Visa Center for you to go and process your green card through the embassy. But again, this is a complicated issue because there is something called 310 and permanent bar. If you overstay your status in the US, if you enter the US legally and you overstay for a period that is less than 180 days, for the purpose of adjustment of status, it is a grace period. If you overstay your status in the US for a period that is 180 days but less than 1 year, anytime you step out of the US, you are barred from returning to the US for a period of 3 years. Now, if you overstay your visa in the US for a period of 1 year or more, anytime you step out of the US, you are barred from returning to the US for a period of 10 years. So now, if you overstay your status in the US for a period of 1 year or more, and you step out of the US and you re-enter the US illegally, then you are permanently barred from entering the US. So, the mere fact that they send your case to the National Visa Center does not necessarily mean that you will be able to come back if you step out of the country. So there are more facts that I will need in order to address this specific situation. Whether you should go for interview or not will depend on a number of things. Like I said, there is 3-year bar, there is 10-year bar, and there is permanent bar. So it is important that you clarify it before you step out. Otherwise, you may step out and not be able to return to the US. Now, on the issue of the employment authorization, so I'm looking at a receipt notice that was issued in February 24, which is probably about 2 weeks. Yeah, it has been taken out completely. It has been taken out completely. So there is no extension. Even the initial 180 days extension has been taken out. But still, for the person who asked that question, I will still go ahead and apply for renewal of the employment authorization. Whether you are able to work or not depends on, you see, this is one of the reasons why I enjoy the practice of law. Something comes to my mind now, which I believe may be a good recipe for litigation. There is a portion of the INA, Immigration and Nationality Act, that says that if you have been working for an employer and you are requesting an extension of your work permit, you may be able to continue working for that employer for up to 10 months while waiting for the approval of the renewal of your application. That statute, I've always used it for OPT situation, H1B situation, R1 situation. I've never had to use it for adjustment of status situation. But again, in this desperate situation, because what is the alternative? To stay at home and not work? That's not even viable in this type of country where you get bills every day. So, what will I do if I'm in your shoes? I will send in my application for employment authorization. Whether they write it in the receipt notice or not, I will continue working, except the employer decide to let me go. But if I'm in your shoes, I am going to continue working. If they raise it later that I work without authorization, I will go back to that provision that I talk about. I mean, what is the alternative? I don't have any alternative. That's what I will do. I can get that specific provision maybe later. I can't remember it off of my head right now, but I know that is in. I have a question on it in this book. Okay, next question. I intentionally want to stay a little longer today because we were absent last week.
But we do have an appointment at 2 with the detention center.
Oh, okay. So what's the time now? 1:38. So how many more time can we take? We can stop at 1:50. That would mean
12 more minutes.
okay. So yeah, we have about 10 more minutes. Okay. Go on and go to the next question. Welcome back. Thank you. Those who are already running a bank account, is it true that the account holder will be asked for proof of citizenship? It is unlikely. Maybe I don't even think that is viable because I know that people who don't live here can still open an account. It is still possible, so I don't think that's an issue.
But not every bank does.
Well, some banks may not want to open it, but I know that, I know a lot of people who have account with Bank of America, they are not even living here. I know people who have account with Wells Fargo, they don't even live here.
To prove legal entry, or they do have to.
Yeah, you may need to prove legal entry. You may need to show copy of your visa, copy of the biometric page of your passport, and all of that. You still need to show all of that, but citizenship, no, I don't think so. Yeah. Next question. Doctor, can I apply for R2 for my son in Nigeria with the current partial ban? I think I already answered this. They are just not going to grant any visa right now because of the ban. Good day, sir, and welcome, sir. Is the applicant of U visa still protected during this administration? To the best of my knowledge, yes. I've not seen any policy otherwise. Victims of U visa, I believe, are still protected. However, I think there is a BIA case that says that in fact, I read the case yesterday. An immigration judge terminated proceedings for somebody who has a pending U visa, so as to allow visa to become current. So the DHL filed an appeal to the BIA, and of course, the BIA in their current state, they agree with the DHS. So they said that the judge was wrong in terminating the case. So I think they remanded the case back. So, but the way I understand this question was whether they are still protected from ICE arrest and all of that. To the best of my knowledge, that has not changed. Next question. Good day, sir. Thank you for good job you are doing. You're welcome. God bless you, sir. Amen. Please, how can I reach you outside this program? Also, can you please enlighten me on the paralegal program in the law industry? Well, can you please tag the person and provide the office numbers?
There's no way we can.
Yeah, we can't tag anybody.
Just tell them to contact us.
Okay, just contact the office. Our number is 817-274-1144 or 817-274-1844. Or alternatively, you can go to our website, oluasekun.lawyer, and schedule an appointment. Next question. Hello, sir. Thank you for your patience and expertise in answering questions. My friend's mom filed for her in October 2019, but unfortunately, the 45th president came into power not quite long and stopped all chain migration. No, this is not true. They have not stopped anything. They have not stopped anything. That is not true. However, she said she got an email in October 2023 from USCIS saying they received her application and working on it. Any question? However, her mom, who is in her 80s, recently had an emergency procedure done and needs someone to support and care for her as her dad is too old to do that. She currently resides in the UK and wants to know if her application can be fast-tracked due to her mom's health. Okay. She said before relocating to the UK in 2023, she applied for a visiting visa in 2020 January from Nigeria but was denied because of the pending application. Okay. Now, this question is full of it is full of misinformation. Yes, a lot of misinformation is included in this question. Number one, President Trump does not have the authority, does not have the legal authority to change immigration law. And immigration law has not changed before or since he came into office. What changed is the enforcement of the law. Prior administrations, they have been enforcing the law with humane angle, whereas this administration, they decided to enforce the law in a draconian way. As you can see, if the attempt by the BIA to even change a legal precedent is what I've been criticizing since morning. So the law has not changed. The law remains the way it is. Chain migration is part of the law and it is still there. The president does not have the authority to cancel it and it has not been cancelled. Having said that, based on the fact that you presented, your friend is probably an adult, meaning that your friend is probably over 21 years old. The way immigration law defines family is not the way that English dictionary defines family. Under the U.S. immigration law, a child of a U.S. citizen who is 21 years and above is not considered part of immediate family. So based on the information you provided, your friend does not fall into the category of immediate family of a U.S. citizen. Why is that distinction necessary? It is necessary because immediate family of a U.S. citizen are given immediate attention and they are given immediate priority. On the other hand, extended families are not given priority. They are not given immediate attention. In fact, they have to join the queue and they cannot get any benefit until they get to their turn on the queue. Okay, before I finish answering this question, can you quickly help me check the priority date for F3 on married children of U.S. citizens and F1 and F3. F1 on married children of U.S. citizens, F3 married children of U.S. citizens. I want to have an idea how many years it is taking right now. So,
Which one for F?
F1 is on married children of U.S. citizens.
November 8th, 2016.
Okay, so for F1, for unmarried children of U.S. citizens who are over 21, assuming that your friend is not married, that will be the category he falls into. So they are currently processing cases that were submitted in 2016. And based on your own fact, Your own case was submitted, your friend's case was submitted in 2019. So number one, the priority date is not current. Number two, it cannot be expedited. This has nothing to do with President Trump. This has nothing to do with any administration. This is the law. U.S. citizens can only petition for immediate family and get immediate attention. And for this purpose, immediate family of a U.S. citizen, they include parents, spouses, and minor children under 21. So because your friend is probably over 21, is going to fall into extended family member. So the case cannot be expedited. This has nothing to do with Donald Trump. This is the law of the land.
And then F3 is September of 2011.
Okay, assuming that your friend is married, that takes the case to F3 categories. And for F3, they are currently processing cases that were submitted in September of 2011. Again, either way, either your friend is married or not, your friend will be expedited. It is not even ripe. They can't even do anything about it for now. That is the law, and it has nothing to do with Donald Trump administration. So that is that. So next question, before hopefully that probably be the last question. I don't know, but let's see. Yeah, to be mistaken as receiving government benefit, even if I applied through the website and there is no indication on the website that it's a government project as a non-immigrant. Is there, where is the beginning? This cannot be the beginning. Or is there, because I don't understand the question, there's no way.
Okay, here.
Okay. As a non-immigrant, I applied to live in an ultra-modern apartment complex with unbelievably cheap rent below market rate. I'm concerned that this may be a government project, and I don't want it to be mistaken as receiving government benefit, even if I applied through the website and there is no indication on the website that it's a government project as a non-immigrant. Well, I don't know the state where you are asking the question from. However, in Texas, which is where I live, this is information that you can easily verify online. You go to the district appraisal office of the county where the property is located. They will tell you, they will give you information about who owns the property. So if it's a government-owned property, you will know. If it's a not government-owned property, you will know. But definitely, if it is not government, it cannot be a public charge. There are a lot of non-profit organizations that are providing different programs. So, but again, depending on where you live, even in your own state, I believe that every state in the United States will have appraisal district because of property tax. Because every single state in the United States, we all pay property tax. And in order to pay property tax, they will appraise the value of the property and tell you what the value is and assess what?
He said he's in Texas.
Oh, he's in Texas. Then that's even easy. So just go to the county where the property is located and search the county appraisal district. For example, if you are in Tarrant County, you go on Google and search Tarrant Appraisal District. If you are in Dallas County, you go to Google, search Dallas Appraisal District. So the appraisal district, once you open that website, it will ask you whether you want to search by owner name or you want to search by property location. So you will select property location. Then it will give you an idea of who owns the property. So you will know whether it is government or not. So that's an easy problem to solve.
But then again, like if he's applying for any type of government benefit, wouldn't they ask him for legal status, like citizenship and stuff like that?
Yeah, so some organizations running government benefit may not ask for those things. So somebody can still be entrapped in that. It's always good to ask questions, but it's better to find out yourself. I think I'm going to have to end here. It's 8 minutes before 2, and I have an appointment with a detained client for 2 o'clock. So before I set up the Zoom meeting with the detention center, it will take me some time. So I will have to end here today. Thank you again for joining us. And as I say, this period will pass. I am confident that it will pass. I do know, and from some of the information that I received since I came back from Nigeria, I think USCIS has resumed conducting asylum interviews. I have a couple of people contacted me yesterday that they have been scheduled to appear for interview. So I want to believe that, even though the 90 days actually end this March, I don't know, maybe they finished ahead of schedule.
One of our clients just got scheduled, but then he got descheduled, like about a week later or 2.
Okay. Well, I've also been told that we have another client who was scheduled and then they descheduled it again. So I don't know, but we will keep you updated as things go. But right now, I have a couple of people who have been scheduled for asylum interview at the asylum office. But if they get cancelled, we will also notify you. But the 90 days that USCIS was given to come up with something, the 90 days will expire at the end of this month. So hopefully we will know where we are going. I want to implore you to keep safe, avoid any problem, avoid any conversation online that can criticize the government. Don't join me in criticizing the government. Like I said, I have nothing to be afraid of. There's nothing they can do for me. I'm a U.S. citizen. Besides, I've been practicing law now for over 3 decades. So if they stop me from practicing at this time, I have nothing to lose. But before they can even succeed at doing that, you can be rest assured that I'm a fighter and I will fight till the end. So keep safe. Until next week, I hope to see you again. I remain yours sincerely, Dr. Olu Asekun. Have a pleasant morning, afternoon, evening, wherever you may be watching us. See you next week by God's grace.